Shirish. Team code 6C representing the appellants and team 1A representing the respondents.
May it please this honorable court. I counsel 6A, your lordship, my team code is 6C, speaker number 1, appearing on behalf of appellant representing the case of Meera versus Shirish and Union of India and Registrar General Supreme Court of India. If your lordship permits, I would like to go with the facts of the case, your lordship. Much obliged, your lordship. Your lordship, the present case is revolving around on basically two issues, your lordship. The first one is a divorce case and another one is a question of national importance that related to the...
Don't repeat again.
Indeed, your lordship.
Don't repeat it.
Indeed.
That's one is enough where you started, but not after every sentence you just question.
Indeed.
That's not good.
With your kind permission.
That you are shown to that, that is not good.
Okay, good. With your kind permission, may I move to the facts of the case? Much obliged. This case is presently regarding two issues. One is divorce case and another is related to the conduct and ethics of judiciary, your lordship. It is coming to the brief facts. There is a couple, Meera and Shirish, who met in New York while working as a financial analyst in one of the prestigious investment bank. 3 years after their marriage, the couple shifted to Bangalore in India in this hypothetical problem. Hereafter, it will be referred as Bangalore in India, your lordship, along with their girl child. 1 year after shifting to Bangalore, the couple developed the differences and respondent number 1, that is Shirish, moved to the family court of Bangalore for seeking decree of divorce under section 13 clause 1 IA of Hindu Marriage Act of 1955. In the family court proceeding, it was alleged by Shirish that Meera, that is petitioner, used to spend most of her time while chatting in Facebook. While not disputing the fact, petitioner accepted the fact, but she also alleged that Shirish also used to go to the frequent excursion organized by Nature's Lovers Club. In the proceedings at family court on X, that is dated X July 2014, family court at Bangalore granted decree of divorce in favor of Shirish. Aggrieved by this, petitioner Meera preferred appeal under section 19 of Family Courts Act in the High Court of Bangalore, where the appeal was dismissed by upholding the decision of family court at Bangalore. Aggrieved by this, the present petitioner Meera has came before approached this court under Article 136, that is special leave petition, before this honorable court. And presently, one more new fact has also evolved that one of the sitting judge in the division bench during the appeal was undisputedly the Facebook friend of respondent number 1, that is Shirish, your lordship. And today's matter has been posted for hearing before this honorable bench. If your lordship is satisfied with the facts of the case, I would like to go with the points for consideration. May I? Much obliged. This honorable court has framed 4 major points for consideration. First 2 points of consideration would be dealt by me, that is points for consideration number 1 and points for consideration number 2. And rest 2, that is 3rd and 4th, would be dealt by my co-counsel, your lordship.
Before you start going to that, what is your importance, whether the judge's conduct or your divorce case?
Indeed, your lordship, all 4 issues have equal value, since 2 issues are related to one of the national interests regarding conduct of judiciary, and presently, as it is very well known that Facebook has become one of the part and parcel of our life. So, and other cases related to the divorce, it is a family where the life of two couples have been involved where they have a girl child. Hence, all the 4 points of consideration are equally important, Your Lordship. May I go with, if Your Lordship permit, I would like to go with the arguments related to points for consideration number 1. This Honorable Court has framed points for consideration number 1 that two judges have right to subscribe to Facebook or social network on web or to invite or accept friends. It is humbly submitted before this Honorable Court that judges do not have right to subscribe to the Facebook or similar social networking site, since the post of judiciary is of high integrity, honesty and character, and it needs to be regulated in a proper manner. Your Lordship, judiciary is a post of high integrity and self-discipline that was held in Tarak Singh versus Jyoti Basu. That judicial discipline is a self-discipline and the responsibility is a self-responsibility. And if the conduct of judge will become timid, then there will be a tendency to compromise between his divine duty and personal interest, Your Lordship. Your Lordship, in one of the leading case, Sri Ravichandran Iyer versus Justice A.M. Bhattacharjee and others, citation 1995, 5 SCC 457, it was held that conduct which is expected by the judiciary is much more than which can be expected from a layman or from an advocate as well. Hence, even the private life of a judge comes under the scrutiny, Your Lordship. And my ultimate contention before this Honorable Court is that uses of Facebook by the judiciary will serve as a threat for independence of judiciary itself. Regarding independence of judiciary means that judiciary should not be only be independent from legislative pressure or executive pressure, but independence of judiciary also includes that judiciary should be free from any kind of prejudices or any other pressure or any kind of influences. That was held in Union of India versus Shakalchan Himatlal case, 1977 for FCC 193, Your Lordship.
Also, is it not hypocritic on your client's part? On one hand, she uses social media, network, etc. And on the other hand, she wants to curtail the powers of the judiciary?
Your Lordship, there lies an intelligible differential. The class which a layman belongs and a judiciary belongs has a much difference, Your Lordship. It is a dignified post, it is a temple of justice. They are, judiciary is something where they have power to even decide about the life of a particular person appearing before this court and seeking justice from that court. But Meera, she is an ordinary citizen. There is a class difference, Your Lordship. Your Lordship, certainly in the case of Your Lordship, in the case of E.P. Royappa versus State of Tamil Nadu, it was held that there would be no discrimination where classification is based on class basis, Your Lordship.
That's exactly what I'm asking.
Indeed, certainly.
You are making a class difference now.
Indeed, Your Lordship.
Your client is social media user and judge is also social media user. Why create a class between them now?
Your Lordship,
Why attack him?
judiciary is a position where they decides the matter, and it will be against the rule of fair hearing that if the party who is a friend of judge and the same judge is dealing the case of that particular person, Your Lordship, they will be certainly against the judicial ethics, Your Lordship. And mostly, Your Lordship, as a resolution passed by this Honorable Court in Reinstatement of Judicial Values 1997, that was passed by full bench of this Honorable Court. In that principle 7 held that a judge should avoid dealing the case where his family, personal interest or friends are involved. I would like to submit a copy for Reinstatement of Judicial Service in Life. That was passed on 7th May 1997 by the full bench of this Honorable Court, Your Lordship. Your Lordship, and
you are using repeatedly the friend, judge is a friend of your husband. How?
Your Lordship, he was the Facebook.
No, alright, I will make it further clear. Friend on social media is different from traditional friendship. Do you agree?
Certainly, Your Lordship, but there are chances.
See, on Facebook, anybody can become a friend of anybody without even meeting, without even seeing each other.
Indeed, Your Lordship.
Correct?
Indeed.
Just I approve that you can be my friend Daksina. then can you allege bias against the judge? Or
Yeah.
say that you are a friend of mine?
Indeed, there are chances of bias, Your Lordship. Since Facebook is a platform where there are chances of bilateral conversation. Facebook is a platform where I have access, if I am a friend of a particular person, I have access to get to know about the personal life of that particular individual. Your Lordship, there are chances that if I am being a party and I am befriended to one of the judge, I can know about the particular instances of the judges, and that also lies vice versa, Your Lordship. That even a judge gets to know about a particular person who has added in that Facebook, Your Lordship. Hence, there are chances that that there will be a chances of development of personal feelings, Your Lordship, since they are also a human being, Your Lordship, and human being is something they are of emotional in nature, and where it comes to emotion, there are chances of bias, Your Lordship,
Now
as happened in the present case.
Facts. What is the material you have placed? Say that they have acquaintance, exchange of thoughts, etc. So that you can say that he is biased. The judge might have posted some his opinions or his thinkings on Facebook, and your husband's client might have accepted it. I approve, excellent comments. Does it mean that the judge is a friend? In traditional form, which is bias, I can understand. But the difference is this: traditional friendship is different from Facebook friendship.
Your Lordship, but
Do you agree first? Do you agree?
indeed, the friendship what was in the earlier times, but Your Lordship, as the time is changing, the friendship what was there in the earlier time and what is there in today's world. Your Lordship, there are much chances that people are not knowing. Your Lordship, there are many instances that where people meet in Facebook and they get married. It happens. Hence, we cannot deny the chances that there are certainly chances that bias can arise, Your Lordship, when the person will get to know about a
So
particular
it is your presumption, not the solid facts, that
possibilities.
the
Are
judge
there.
is biased.
Since regarding the facts, it only states that Shirish liked the post of judge who was sitting in the division bench.
That's all.
Your Lordship, but certainly.
Now so many people, we write, my lord has written judgments. People say that excellent judgment in the newspaper. So they become our friends.
Certainly not, Your Lordship. Your Lordship, but there is a difference between making general comment and I beg your pardon, Your Lordship. I beg your
This is a division bench, my lord is by the law. It's a division bench judgment. The judge alone has not contributed. Two friends have applied.
Your Lordship, while it is undisputed that it was a division bench, but Your Lordship, there are possibilities that one judge has power to influence the order of another judge. Your Lordship, upon this, I would like to
It's too much to say that. It is too much to say that judge might have influenced the other judge.
Certainly not, Your Lordship. In the Suren Singh case, Your Lordship, AIR 1954, SC 2176, it was held that judges may discuss among themselves, they may even exchange, they may interact themselves, they may even exchange the draft and they may come to the conclusion, Your Lordship. This was held in AIR 1954 judges case. Hence, Your Lordship, here in the present case also there is a possibility that
Bias has got to be inferred from the vertex. What are the vertex here?
Your Lordship, bias need to.
Bias is a matter which can be inferred from the vertex. What are the vertex? You are anything against
I couldn't get. I beg your pardon, Your Lordship.
vertex?
I apologize. I couldn't hear.
Bias is to be inferred from the various vertex.
Indeed, Your Lordship.
What are the vertex here?
Your Lordship,
Nothing.
certainly the facts are silent. Then when the facts are silent, they need to be drawn through a certain presumption. Your Lordship, as I would like to differ a little bit, as in the criminal cases, as we derive a conclusion through the circumstantial stances. In the same way, in the present case also, since the facts are silent, then we have to make certain presumption, Your Lordship.
The
Most of your arguments are based on possibilities and presumptions.
Your,
Facts.
your Lordship, indeed there are likely out of bias, and as per there are international conventions which also says that a judge should avoid personal interest in that, and Your Lordship, it is a very well settled maxim, nemo judex causa and propria, and propria, where it was held that no one should be a judge in his own cause.
He has no personal cause, he has no personal interest at all.
Your Lordship, friendship derives a personal interest. What kind of friendship it is, that is subject to correction and investigation, Your Lordship. But prima facie, what a layman can make in his mind, I would like to request for the extension of time if this honorable court permits.
You are aware that the trial court has decided the case against you, and now if the appellate court has not interfered in any way, then what is the attribution?
Your Lordship, when it comes to first appeal, under section 19 of Family Courts Act, court has to draw the line between facts as well as question of law, question of facts and question of law in section 19 of Family Courts Act. And Your Lordship, as it is stated in Bakshiram versus State of Punjab, that first court of appeal which decides on facts must apply its independent mind, records its own findings on the basis of own assessment of evidence. And Your Lordship, mere reproduction of assessments of trial court may not be sufficient. Your Lordship, hence if the High Court mere upholded the order. High Court had already just upholded the order, they did not state any reason. It was something similar to non-speaking order, Your Lordship.
The High Court can reassess the evidence, that's a different matter. It is not your allegation that High Court has not properly reassessed. You are only alleging that he being a friend, he is biased.
That's all.
Your case is nothing on merits. This is what we are trying to find out. Your only allegation is judge is biased, set it aside, that's all. And take action against the judiciary by framing rules, etc.
Your Lordship, the definition of bias laid down in many instances, like H.N.L.U versus Managing Director Dr. Ray Ram Singh Higher Secondary School. In that case, certain test of bias was laid down. That whether there was a real likelihood of bias depends not upon what actually was done, but what is appearing, what appears to be done, Your Lordship. Then the test of bias is whether the intelligent man, fully apprised of all circumstances, will feel serious and apprehension of bias. This case was referred by while referring the case of R versus Rajana versus Success Justice. In this case, it was held that by referring this case, this honorable court has held that apprehension of bias should be derived that what is appearing